Foster Power is a movement to improve the lives and futures of youth in Florida's foster care system by creating access to information on their benefits, protections, and legal rights. Foster Power is the first app of its kind nationwide and was made by lawyers with youth input. Visit fosterpower.org/app to download the free mobile app today.
Hello and welcome to the Imprint Weekly Podcast. I'm John Kelly, Senior Editor of The Imprint, a daily news site covering child welfare and youth justice around the country. You can read all of our coverage at imprintnews.org or check us out on Facebook or Twitter at The Imprint News. You can sign up on our homepage for our free weekly and monthly newsletters, and for professionals in child welfare and youth justice, subscribe to our Youth Services Insider section for a closer look at news on business policy and practice. The Imprint Weekly Podcast is also a member of the Safe Camp Audio Network. You can check out our show page and all of Safe Camp's other great podcasts at safecampaudio.org or on social media at Safe Camp Audio. We're going to go straight to the old interview today. On today's episode, Jey Rajaraman, Associate Director of Litigation, Children, and the Law for the American Bar Association, joins us to talk about the Biden administration's new proposal around the use of federal funds to pay for legal counsel. Jey is really the perfect person to have for this because as a leader at the American Bar Association, she will be prominently involved in kind of helping states connect to the new permissions if this rule goes through. And she was also, for 16 years, the Chief Counsel for Legal Services of New Jersey. And in that position, she oversaw parent counsel for a lot of the state, also set up what's called a Pre-Petition legal counsel clinic. And so we're going to talk a little bit about that in the context of this new rule as well. Before we get to our conversation with Jey, just two quick notes. One, on Tuesday, November 21st at 1 p.m. Eastern Time, you can join our Youth Voices Rising team for an event they are having online called Redefining Holidays, How to Navigate Triggering Times. They're going to offer tips and advice to foster youth as the winter holidays approach, which often stirs up difficult memories and feelings for some people. Come learn some methods to find community and empower yourself and others. Panelists will also offer advice to caregivers and social workers on ways that they can help you through these difficult times, as well as others like birthdays and the other holidays. Panelists also will speak on ways to incorporate inclusion for those who have no family to visit on special days. If you want to sign up for this completely free, you can hit up imprintnews.org/events. Second quick plug, it is Newsmatch season. The Imprint is a proud member of the Institute for Nonprofit News, which has hundreds of members around the country now. And Newsmatch is our end-of-year campaign for all of us nonprofit newsrooms to bring in new and recurring donors. From now until the end of the year, if you donate to the Imprint, we can match your contribution, and we're eligible for certain Newsmatch incentives. So there's no better time to help us continue to report on all the important news that other outlets just won't do when it comes to child welfare, youth justice, and more. To support the Imprint during Newsmatch season, just visit imprintnews.org/donate. That is imprintnews.org/donate. All right, without further ado, here is our conversation with Jey Rajaraman of the American Bar Association. All right, we are joined today by Jey Rajaraman, Associate Director of Litigation, Children, and the Law for the American Bar Association. She also spent 16 years as Chief Counsel for Legal Services of New Jersey, leading the state's representation of parents involved in the child welfare system. So Jey has kindly agreed to come on here and help me break down all the things when it comes to the Biden administration's new proposal around the use of federal funds to pay for legal counsel. I know that sounds really exciting, a Federal Register notice about a proposed rule, but it is very important. So I appreciate Jey jumping on with us. Thanks for joining us on the Imprint Weekly Podcast.
Happy to be here, and thank you. And I'm very excited to talk about this with you.
All right, first things first, we got to get them to know you a little bit. You got to give me at least one favorite. You can give me more if you want. It's up to you. Categories are TV, show, movie, book, musical group, or sports team? I think I got to widen this out. I've been getting the same answer, so maybe I'll do that next time. But you can feel free to go far afield with that, but there's the 5 main ones. What do you got?
I'm going to start with a book. I'm going to go as I'm staring at all the books to my left, and not a child welfare book, which is, or books that I've been reading, but my good friend Anissa Rahman just wrote her memoir, a partial memoir called An American Mio. And it's her incredible story returning to her roots and her family's story in India, and having Indian background very different from hers, but her discovery of her father and her mother's tales and a part of India I had no understanding or familiarity with. It's just been a remarkable read. It's a beautiful read. It's mixed with photos and poems. So it's just a really well done, beautiful story. And so I would share that. And then I rotate when I need breaks. I think I've also really enjoyed Elise Lowen's book on our best behavior. She's taking on the patriarchy. So, you can always learn something from her book. Also memoir. So I'm in this memoir state, I think. And both a high recommend, and you're learning something, but it's not child welfare, or there's always linkages, but yeah, I would encourage those who are interested in reading to pick those up.
Got it. So you're a big reader. Free time books, and it's like the year of the book in child welfare, so it's probably kind of
right. Yes, I am a big time. I mean, I did get to see Lauryn Hill in concert recently.
Oh, you went? How was it? And how late was she?
2.5 hours, but it was in Newark, a hometown. And we were prepared, so it was okay. And it was just, she had her marching band from her local high school there. Awesome. It was awesome. So it was totally worth the wait. And I saw her years ago, and then to see her again in this way, in this time, referencing her old albums, it was just great. And the Fugees came out, so it was great.
Oh, man, that's amazing. Yeah. All right, so let's talk some legal counsel. I'm going to try and set this up, and then I want you to correct or fill in anything I've missed leading up to what we got out of the Biden administration last month. I think it was last month. So, okay, just set up fact number one. I think with people who aren't on the well-versed on the legal side of child welfare, there's not really a constitutionally guaranteed right to counsel. I think there's some people that feel that there could be some cases to be made on that. But right now, we do not carry it in child welfare as if everybody has the right to counsel. Most states have some guarantee, but it might not, be early in the process, might come after foster care is already, removal's already happened, or even termination of parental rights. And this is a notoriously under-resourced segment of the system. So far, correct? On the big picture? Okay.
Yes, that sounds right.
And then in 2018, the officials at the Trump administration just very quietly changed federal policy, kind of by just clarifying something. There's this thing called the Child Welfare Policy Manual. Anybody can go to it online. It's kind of presented in this Q&A fashion. And all of a sudden, it used to just say that, okay, you can use Title 4E entitlement dollars. That's the biggest, pot of federal money for child welfare expenses. For legal counsel, you used to only be able to use it for the agency. The agency going to court, you could cover 50% of the cost of that. Now, as this clarification happens, you are allowed to do that, but you are also allowed to get the 50% 4E match for counsel for kids and for counsel for parents. So on one level, this proposed rule here is kind of just codifying that and making it more official. Somewhere now in between, just it's in a Q&A. It's not exactly in a law, but this is now a federal rule that they're proposing to make. But it also proposed some further expansion of the scope of what would be allowed in terms of expenses on legal counsel. So can you walk readers through sort of what the major additions are in this proposal that the Biden administration is putting forward?
Sure. And just to emphasize and support why this is even important, going from a manual to a regulation, as you know, from end of 2018 or 2019, there's been a great deal of work and drawdown. And I was looking at the stats, and it's available on the ACF website. About 26 jurisdictions have drawn down 4E funding based on this manual change, 11 doing pre-petition. So I'll touch on that. But so the concern is always, though, because it's a manual, right? What authority does it have, right? Is there this fearing of flexibility? And what you were hitting on, how many people unlike maybe people like me, live and breathe in the manual or your state's manual or agency manual to take advantage of it or understand it to the extent that we should, explore manual changes and recommendations. Again, this is a regulation, not statute, so it's not as firm as a law, but it is having a stronger authority, more persuasive authority. So that's a plus and provides sort of the protections that those who were concerned earlier with having this codified would be a big difference. It also would solidify all the things that you sort of mentioned, like we believe in counsel and right to counsel, or where it can be available, funding it is valuable and relevant to families that are involved with the child welfare system. So all really positive. So just thrilling and exciting that all the work that has been happening in these programs are being recognized and that this is being valued by the Biden administration.
Yeah. And just a quick, to add on to that, when I think of the difference between this just being part of that manual and what this would achieve, I think one thing that comes to mind for me is, there's been for I don't know how many years now, this back and forth about what data the federal agency is going to collect about foster care through this program that's called AFCARS. The Obama administration, on their way out, finalized a rule about some new stuff. Then Trump froze that rule. And then his administration rewrote that rule. But that ended up in court. And I think that's maybe the significance. It's not a law, but I mean, put it this way, it'd be hard to see a slight change back in the policy manual being an instigation of a legal challenge, whereas this rulemaking process, courts do consider it, I think.
I agree. And even on a state level practicing in New Jersey, I spend a lot of time with agency regulations and how it functions, right? What is required of the agency to function. And that isn't typically statutory. That is regulatory. And that's not unusual to child welfare. That's TANF, that's Medicaid. When you're looking at TANF, everything is regs. You have to be on top of the regulations to be able to receive the benefits and enforce the benefits for your clients. Yeah. And so I see that as a parallel and exciting that this is being lifted up and what it can mean for legal advocates and defense advocates, especially.
Well said. Okay, I took us off topic though. So hit them with what has been added to just you can now help pay for parents and kids counsel. So it's more than that now. What are they proposing?
Yeah. So the big three things that I would want to extend is that this extends to tribal representation, extension to pre-petition. Now, before 4E was really clear on post-petition legal advocacy. Now this is pre-tribal and multidisciplinary models and kinship. So it's enforcing what practices have been occurring, but now again, making it clear and codifying it. The big thing that, as to multidisciplinary models, that includes the social workers, lived expertise, impacted parents and youth have been a large addition, contribution, leading projects, leading programs, and actually doing this work. So that is now included as part of the model that's being lifted up. Pre-petition, which is what I'm closest to and most passionate in so many ways in legal advocacy, has now been identified. And a large part of the role, which I encourage everyone to read the 40-something pages that's available, and that was issued on, I believe, the September 28th, goes into great detail of why this is now being picked up. We have learned that 11 jurisdictions have been drawing down 4E prior, but it wasn't clear. It was sort of, again, like the basic 101. It is the program creating a state contract case plan with their 4E agency within their jurisdiction. And so what we've learned is that agencies, 4E agencies, along with these programs, value the upstream model, the early legal advocacy model. And that can include various types of legal advocacy, including what are your rights for a parent when they're being investigated? What are their rights when they're developing a case plan or a prevention plan? Know your rights. What happens if the agency knocks on your door? Do you have right to counsel? Projects have been taking this on, including New Jersey's Legal Services Project, which hasn't drawn down 4E funding, but they've been doing the prevention work. And this is an opportunity for programs to start to look at this funding. Is this something that can actually grow their project or stabilize it or revisit the question of working with their agency to draw down these funds?
So just to be clear on that pre-petition part, which I want to drill down more on, if I'm hearing you right, there's 26 states that have drawn any amount of money already using this, and that 11 of those 26, you have some way of knowing that those 11 have used this for what you're describing as pre-petition work already.
Correct.
Okay.
Yes, it's been identified on the website as prevention. So, and then working with some of these programs closely, we've learned that they have, in the ways I've described it, with civil legal representation in these areas, doing prevention work, early legal advocacy work.
I don't want to skate by like just what this means, because I don't think everybody just knows like, oh, pre-petition. The petition usually comes in when they're trying to take a kid into foster care. And that's sort of the jump off point for legal counsel appointment in most of the country at this point. When you say pre-petition, typically that means there is some sort of the child welfare system has already come into the orbit of a family, or else 4E is kind of hard to use, but it's not gotten to the point or nobody's made the decision or sought out in court a removal of a child. Is that the best way to understand it, or probably more nuanced?
Yes. And I actually say anti-separation work, because I think you're right. I think there is this confusion of, are we preventing the abuse or neglect? Are we preventing the petition to be filed? If we get early in, we being legal defense, getting early in enough, can we stop the agency from taking the child? And when I landed on anti-separation, I mean not removing that child or separating that family. And that could take on many variations of legal representation, assistance, advocacy, including know your rights, education, training. It also includes, I was thinking about mandated reporting and the trainings that legal services in numerous jurisdictions are going out to schools and hospitals of, who am I supposed to call? That's a form of prevention, right? That's a form of preventing involvement in a family's life, or saying, if you are struggling with these questions, can I call an attorney? And who is that attorney? Who are those resources? What information is available? So I like to say it is a larger umbrella, and the work that can be done should be left to the discretion of the program and the 4E agency that's sort of developing this relationship. So typically right now, I think you describe many of the examples that exist now, which is that agency involvement. There is maybe an investigation or a call has gone out, and the family is like, how do I navigate this investigation? What are my rights? Or there's a case plan, or I'm being asked to, do services or quote unquote comply or be involved with this agency, and I don't know what to sign, or I would like this interpreted to me, or I'm afraid this will affect my criminal case or my treatment program or my job. These are all questions where I think as I list them, I would be jumping up and down for an attorney to help me navigate this. And it's really critical to have that support and due process. And this is also linked up, as you've reported so well and throughout not only podcasts, but through the imprint, about how many of these investigations and cases are linked to poverty-related issues or access and resource issues. And again, looping back to this notice of rule and this regulation, it emphasizes that. It also declares, yes, the large involvement between agency and family is linked to access to resources, barriers, poverty-linked issues, poor housing, unaffordable housing, access to treatment programs, not what we believe, or maybe nationally what is understood to mean abuse or neglect, or what neglect or gross negligence means. And so when providing attorneys at these earlier stages, navigating these issues, either navigating the process with the agency or resolving these legal issues that pull the agency in, that has reduced the need of foster care or increased involvement with the agency.
So you were involved in getting a pre-petition, program up and running in New Jersey. I think you got started in 2018, right? So like right around the same time as this initial permission. This in the proposed rule, they give some examples of the types of things that could come of this. And I mean, me and Jey are talking largely about parents right now, but this certainly applies to kids too. But they said, parents who need help with housing, paternity tests that can kind of get things right in terms of where a child could, a lot of other stuff. But I'm just asking for your perspective as somebody that was on the front line of this thing. What were the needs on the parent side in particular that you guys most dealt with that was most ameliorative and anti-separation effective, let's say?
Yes, housing. Lack of housing. I think everyone, and when I left legal services, it was over 300 cases. I think everyone had some sort of housing barrier issue. Either they were being evicted for rent, on payment of rent, or it was unstable or non-affordable housing, or they were losing their housing voucher, or it was a HUD issue, or under welfare TANF, they were losing their rental assistance. And these were denials, right? These are all legal barriers, decisions that when we became involved, we were either able to resolve or result in some sort of settlement. And while we were advocating for the family on the housing end, we were working with the agency saying, hey, this is not a reason to remove or separate the child from the family or deepen your involvement. And they were really thrilled and supportive of legal services helping this family.
I think that's what I wanted to know also. So the housing, okay, that does seem like the most major reason. But it's sort of the last thing you said that I was wondering. So is it accurate to say that in the majority or in all of the cases, these parents were coming into your orbit to get help with these situations after already there had been some involvement with child welfare? I guess looking at it the other way, could I have called you and said, Jay, I'm about to get evicted. I'm afraid that CPS might come knocking. They haven't yet. Can you help me? Like, is that the difference right now?
Yes, I think both. And we're fortunate to do both. And I think our model in New Jersey lend itself and still lends itself to do that. So yes, when we started the formal program, we received many referrals from the agency. So there was agency involvement saying, we really don't know what to do here. And we don't have the legal expertise. We don't have like a legal services housing attorney on staff to represent them. There's conflicts, right? We're investigating them, we can't assign an attorney. So it worked and the majority of referrals that way. But during COVID, and something you're hitting on, when the eviction moratorium took place, we could see the numbers reduce for eviction filings. And then when the moratorium changed and was, taken back, there were filings increased. And the legal service community, we did outreach and training saying anyone who has children is at risk of having a call taken. This is not unusual to communities living below a certain income threshold, especially brown and Black families are known to hear that. That is not unusual to say, I don't want the agency DCPP to be called on me by my landlord or by the court staff or by a neighbor or by the school. This gets out and I'm about to be homeless on the streets. I don't have a voucher to get into a shelter. So what do we do if we can get in earlier? So know your rights and anticipating the potential call. And it's not necessarily like agency, you're the bad guy, but it's like, hey, we're here, we're navigating this legal issue. What can you do to assist and support this family? Often would happen. And then ensuring that there isn't a separation. And so it is both. And that actually really, again, going to this rule, encouraged my legal services colleagues to be interested in child welfare. They're really not interested in child welfare. Like, I don't want to deal with another system, right? But when I talk to housing attorneys, they're like, oh, right, we have the same families. We have the same clients. So our landlord tenant and housing projects were interested, and we did joint work together early on, overlapping these issues, especially with welfare. A lot of it was that rental assistance. And there's actual regulations, going back to regulations on the welfare side, that if you're at risk of losing your children, that's an exception to many of the welfare rules, extending benefits and rental assistance. And they didn't know how to get that letter or that support from the agency side. So we would often fill in the gaps and advocate and sort of secure housing or assistance in many ways early on, before there was even an investigation or early on in the investigation. And what was fantastic, the only lawyer, to be honest, outside of like the landlord's attorney or the attorney's maybe filing the complaints, was the parent's attorney. And so it was parent-led. It was family-grounded. The children are safely with the parent. It just felt like the parent had control and authority and autonomy on the legal decisions and felt supported. And that was remarkable. That's still, all of a sudden, that changed sort of the way families felt about navigating a system where they feel often never heard, or what happens post-petition, where it's, as we know, they're not seen or heard often, or feel like they're advocating for what they identify as urgent and important to get their children back, or, extend the length of time in foster care.
Hi, everyone. It's journalist Lisa Ling, and I'm sure you will agree that it is so important for there to be good, trustworthy journalism on children and families, and nobody does that better than The Imprint. I am such a devotee of the imprint, and I listen to the Imprint Weekly podcast because it is so comprehensive and so substantive, and it is by far the best news source for anyone interested in critical issues like foster care, juvenile justice, youth homelessness, and so much more. During this holiday season of giving, I hope you'll consider donating to the imprint. If you do so between now and the end of the year, your donation will be doubled thanks to the National Newsmatch campaign. To give is so easy. Go to imprintnews.org/donate. That's imprintnews.org/donate. Thank you so, so much.
I wanted to ask for your thoughts on the relative piece of this. And I think to describe, in my mind, that's I don't want to say thorniest, but it's the most complex of these. And here's a good contrast for that. The most straightforward is including support for tribal governments, because per the Indian Child Welfare Act, the most unique aspect of ICWA cases is that tribes have a right to intervene. That is just unique. And it's kind of honestly like it would be weird to not offer them the same, avail the same legal counsel support. Now, relatives constitute, I would imagine, in some cases, they will not end up being an official party to a case. So you're actually really talking about legal counsel being paid for people that are not actually going to have the same standing in court. Well, they would in others. And I just think this is like a messy area. You just described a situation where grandma is working hand in hand with the family. It's not always that simple. Relatives they may not always agree with parents and vice versa, they can be messier than that. So I don't know. I just am curious for your thoughts on how this will go. But I do think, I will say, it does seem of the three groups like the one most in need of some sort of like acknowledgement of their legal rights, because you just hear all the time about relatives who are they get a knock at the door in the middle of the night, they take a kid, they opt for options that will not support them with financial support for the kid or any sort of rights in a case. I'm blabbing now, but what are your thoughts on this?
Right. No, and I'm glad you raised that. And to be clear, and this is something we're hoping to clarify through our comments with the ABA, and I think other organizations feel the same. We're not suggesting post-removal there isn't right to counsel to foster parents or kin. And we're not suggesting that be the case when, as you outlined earlier on, there's not right to counsel for parents in every jurisdiction or for children. And so we're not suggesting to pit kin against family, to be clear, or elevate their party status. And I hope our reading is that that's not the intent here. I think you're exactly right. When kin are identified as the guardian, as the one that is the plan for the child, that they are often lost without navigating the system and are seeking assistance. And to mirror the current licensing rule, that regulation that just was codified and passed recently about a few weeks prior to this. And so that, I think it will resemble that, and hope is that, yes, kinship, those kin caregivers need access to attorney support in those situations. But I do want to be clear, my hope is that it would not pit parents to kin. I also think kind of this narrative that kin caregivers and parents aren't together in community when the agency gets involved. That's not been my experience. Many times the families I'm representing, they live in one household. And then the issue is, hey, mom, you need to get out of the house, or grandma, you go file for custody to keep this child safe, right? Quote unquote. And in fact, so many times you don't need to do those things. And that's been my prevention work. So if mom is needing to enter, say, a treatment program and will be out of the home the majority of the day, the child's under 3, needs daycare, but grandma's at home, you could do a power of attorney. There's former guardianships. You don't need to go file in court. There's a lot of nuanced legal parameters that I can do for grandma, not in violations of anyone's right. And no one needs to go to court. There's no agency intervention. There's no requirement for licensing or funding. And that's being like the narrative that's elevated often for kin. There's absolutely need. There's the kinship navigator system. There's other programs that are alternative to these agency involved cases where it's different. And yes, absolutely. Like we know when we represent grandma, say at legal services, we have one client, ethics rules and attorney-client privilege, all the governing rules of what it means to represent a client is understood at the inception of that retainer and representation. But I've never had a case, and none of my colleagues have ever had a case where when you're not trying to pit or divide the family unit, they're in uniform cause to keep this family safe and feel better about remaining safely together and having an attorney seeing all the points. Of course, we make clear that if there is a disagreement that does happen, it definitely happens post removal. I've definitely represented parents where the in-laws or the grandparents from the father or mother or the other side of the child's connections are in disagreement, who are also even maybe called the hotline themselves. I mean, it is, families are complicated and difficult, but I think for the heart of these issues is that we're trying to keep the family of origin, whatever that may look like, together and keep that secure through right of counsel. And that could be aunt and grandma. Like that, I think, is the reality of families that exist today. So that's how I see it. It's not maybe always the parent. That can look different for every family, but not to elevate or pit status and family statuses post removal or even in pre-petition, and give that discretion to the program to see what serves that community best.
I think I hope I can articulate this well. I'm not sure I will. But what it seems like when you just piece together some developments over the last few years, let's start in 2018 with the passage of the Family First Prevention Services Act, right? And this new rule and the other rule that the Biden administration had already circulated, now finalized, around, a different path to approving kinship caregivers that recognizes they are different than just a stranger licensed in foster care. When you look at the totality, there's a clear movement afoot to just recognize that we ought to be prioritizing relatives. We ought to be helping them with this very complex system. But it's all, to me, it's like a little bit avoiding the question of is it advantageous or better to have them on the pre-petition side of the coin or the removal. And the reason that I say that is because the one thing it seems to me that it's very hard to secure for relatives and kin is the financial support they deserve if they're going to have a kid for any amount of time, right? Like some of these cases involve them taking a child in while things are right. And like, I think the preference of everybody is largely like, well, if we can do that without like the stigma of like, we're taking a child and removing them in court, they'd want to do that. But you know what I mean? Like this gets to hidden foster care versus formal, right, what you get in both. And I think we're moving towards like codifying more support for kin. And it's just, at some point they'll have to answer the question of like that financial piece of can we figure out a way to support them without a removal on paper or not,
Yeah, I think there are financial supports for families through other means. And I think it's the legal requirement. So, for example, like if you're going for welfare benefits, what is the legal document that shows that you're part of a family unit? Maybe it is the lessening of not a guardianship requirement, but a custody requirement, and it could be joint. I mean, and that happens a lot. Like I think I've often had grandmas call and say, well, I need to get this type of order because I'm picking up the children from school, or I have to take them to the doctor. I'm like, what doctor is asking you for a court order? That's just not true. Or what a pickup, you need the parent to put your name down or not put your name down, right? I said, so, what is actually needed to meet the needs of your child and what's required? And if it's financial, then we have to look at our welfare rules. We have to look outside the need. If the financial solution is you need a removal and a licensing because kin needs financial support, I think we need a societal look back and take a step back.
I totally agree. But I think in the present moment, one of the things that you'd most want kin to have a lawyer around for is that moment where they're thinking of agreeing to taking a child temporarily through a safety plan, very informally, but with CPS involved. And a lawyer could say, and this is where it gets dicey, I would imagine for you, like that lawyer's advice might be like, look, if you feel like you need financial help to make this work, we should probably try to get you approved as a foster parent and get them to remove. You know what I mean? Like that,
right,
those are
right. That
sticky
is,
things.
and I think that's what's maybe broken, right? If it has to be a removal or a fine, because a removal is a finding of abuse and neglect, imminent danger. It's not like a wink, wink, nudge, nudge.
No,
it is significantly damaging, and judicial requirements have to be made against the parent, the ones that are
correct.
Right. Yeah. So I think if
the relative could lose the relative could lose the child.
And whoever that parent, it could be. And so the benefit of, I think I've done a lot of custody and non-child welfare cases. So there's a world of family dockets that permit this, and collecting of child support through federal means, state means. It might not be as uniform or as structured or the level amounts. I understand that, but there are families that pursue assistance, and you don't need a finding and something this detrimental dramatic of what happens with a finding or removal. So I urge us to, if it goes to the financial component, where I agree, poor families need assistance, families who need struggle, absolutely. But this shouldn't be the segue or this, the sidetracking to serve that. And there's so much actually available to kin outside of this. And again, that's why it's good to have lawyers involved to say, here are the alternatives. When you actually feel, if there isn't a desire that you think this child should be removed, or I want to remain in the household with mom or dad, or whoever the allegations against, I don't want a finding. Many times grandparents say, yes, I think there's a need. There's an emergency now, but I want my son to come back, and not understanding, again, it's not a custody battle between grandma and son or mom, right? This is an agency prosecuting a parent or whoever the initial guardian is. And so that has different requirements and standards, and can't pivot on the financial component.
Right. The most optimistic view of all of this would be to say that if we had lawyers in the lives of kin more often in these early stages of cases, eventually this would probably have to come to the forefront, and people would have to figure this out once and for all.
Yes. That's the reality of lawyering. I'm not, there's going to be difference of opinions, or who should be challenging what, or who is entitled to what. But the heart of it can't be the financial component, like we sort of described in the strategy of which forum to pursue, and if it really is access to support, why do we need a finding or removal to provide that to kin? And, I just don't see that to be the solution, and when there are alternative solutions.
Okay, so the rules have been out for a few weeks now. I know you've had a chance to digest, and so you've alluded to this a couple of times, but are you, and I guess when I ask you as the ABA, planning to, can you just kind of articulate what things you'd like to see them consider? And would it be fair to say that, as is, you are supportive of this? There are things you'd like to see, but this as
yes, absolutely, yes.
Yeah. Okay.
Right. No, I think codifying the manual changes would be incredibly helpful for the counsel points that we've been talking about. The type of work, like what actually is prevention, anti-separation work, the depth of it, the wealth of all the different alternatives and opportunities. I would love for organizations, programs to get excited about what they can do for families. So many programs say, well, I don't want to, work with the parents during the investigation stage. But we have many agencies or programs that say, oh, well, I don't mind representing mom in a domestic violence matter, or a registry appeal so they can get employed, or fix their credit score, or appeal an unemployment. I can do that in my firm. And if I can get assistance, or I'm a sole practitioner and I would like to do this, but I directly don't want to represent that family in an abuse and neglect proceeding. So it would be great to sort of stress all the different types of works and the examples that were given, but we're going to encourage sort of those who are commenting to really illustrate the works and types that they're able to do and would like to be involved in. There's been such creative programs with First Clinic and, in Washington State, there's several California programs where pregnant youth are getting prevention assistance, so they remain with their child after birth with prevention work. The registry appeals, like I said, know your rights trainings all different types of prevention work or anti-separation work. And also, even though I'm describing many examples, I think it will be absolutely cost saving because the hope is to reduce removals in foster care and reduce long-term what the system can hold. It's, as we have said, it's not doing what it's intended to do, and it's quite broken in many ways. And if there could be a way of kind of reconstructing this, I really think this is a place to grow. So we are going to support that. I guess the other, just something that you had said, and just a bigger picture, just to illustrate, we love the work and the prevention work, but I do want to note that even when we fail, it can happen, right? Representing these families in, say, a landlord-tenant matter or not getting that restraining order or guardianship matter, it doesn't mean or equate that the agency should remove that child or that the case should grow or deepen because the civil issue was not resolved. I just felt the urge to say that because I think often we think this will be the silver bullet and solve everything. And, that's just not true to legal proceedings or practice. But we don't want to equate that having right to counsel or poverty is not neglect, meaning that, if you don't solve the poverty issue, that equates to a removal. And so that I just would like to clarify and make sure that this is wealth investing in, even if you're not always successful in these legal matters. But the hope is that informing parents and families of their rights, options, having information about all the different proceedings, challenging the issues that sort of invite the agency involvement or getting deeper in that family's lives will be greatly reduced.
All right. So last thing for you, let's say this becomes a finalized rule. What are you thinking about next? What is the ABA? What do you expect that, you and others at the ABA's role will be for the next 5 years after this becomes codified?
Right. We're committed to supporting programs and taking this on. So training, education, technical assistance, being a resource for any program or jurisdiction who's like, wait, can I take advantage of this? I'm interested in doing this. I want to start this in my program. Or I'm a solo practitioner in Iowa and I want to know who's doing this because I'm representing a parent or kin. How do I get connected? So growing the network and then really supporting and growing programs that are interested in valuing this work is where we are. So we do plan in hopes of this passing quite quickly, we hope. I know there's about 60 days of review from Congress after the 27th when comments are due. But in hopes of after it being finalized, we do plan to support through various venues and media platforms to sort of assist programs and individuals doing this work.
What's what in your experience, because you've helped stand this up in your own state, in Jersey, and then, you've been around now on the national scene, helping, I'm sure, and giving advice to people. What is the job one barrier that most places have with this? Is it as simple as, how do I set up 4E billing or an MOU with lawyers? What is the first thing that they're just I don't know how to do this?
It's a great question. I've seen it vary from exactly that, what's a state plan? How do I work with my 4E agency to come to an agreement? That was originally a lot of the issues in 2019 when this started. And I would really encourage those to look to Washington and Colorado, Iowa, states that have developed great language. We are actually doing a webinar next Tuesday on this, and we'll have individuals from those states to speak on that. But that is the first concern, how do I actually come to an agreement? What does that look like? I mean, originally there were issues of, the agency has no right to look at my client files or have control over my case planning. That's been pretty much resolved. We're not hearing that as much because of the, ethics rules. And again, this is a lawyer-client privileged confidential relationship. And that's not the point of the funding and no way to distort those issues. The other issue is how do I start this? What do I do? I don't want to be overwhelmed with referrals, or will I get referrals and not enough of a place in the community? Who's going to call me? What work do I take on? And we just urge, it really is what your program is capable of doing, what you're interested in doing. As we know, 4E is also not only just creating this program, it resulted in much needed raises, for attorneys and social workers and peer advocates, creating these multidisciplinary programs. So again, it's like kind of taking stock of what you're interested in, what you're passionate about, what your firm or organization is, and then see what you can do. There's so much variance in what each program looks like. So I just stress that, like, just jump in. I was sort of, as those who know what happened in New Jersey, we just took it on really honestly by accident, by having a relationship with the agency and then getting tons and tons of referrals to meet their needs, to meet our community needs. And I just encourage those who are interested not to be afraid. And now there's so many more resources that are available through Emily Cook, who through the Emory College, she has a program like a monthly prevention gathering, and you can directly hear from programs on different stages where they are in developing their programs in prevention work, early legal advocacy work. So to jump in and not be afraid, and definitely call so many people who are doing this work. But there's so much you can do now, and it really is up to you and what you're comfortable doing in your state.
Jey Rajaraman of the American Bar Association, thanks for joining us on the Imprint Weekly Podcast.
Thank you. Thanks so much for having me.
Thanks to Jey Rajaraman, Associate Director of Litigation, Children in the Law for the American Bar Association, for joining us today. And thanks to Foster Power, a movement to improve the lives and futures of youth in foster care by creating access to information on their benefits, protections, and legal rights, for sponsoring this episode of the Imprint Weekly Podcast. The Imprint Weekly Podcast is a production of the Safe Camp Audio Network, which is a division of Fostering Media Connections. Please visit safecampaudio.org on the web or at safecampaudio on all major social media. This podcast is produced and mixed by Christine Anjoko, with music by Luke Giroux and Cyrus Elia. If you enjoyed this episode, we would love it if you consider subscribing or giving us a 5-star rating on Apple, Spotify, or wherever you download your podcasts. And we would greatly appreciate if you would consider supporting our work here on the podcast and in print. Small donations from our listeners and readers go a long way towards helping us grow and cover more great stories in child welfare and youth justice. So support us. It's very easy. Just visit imprintnews.org/donate. You can follow The Imprint on Twitter and Facebook by searching the handle @TheImprintNews, and you can visit us on the web at imprintnews.org. You can always get us over email at tips@imprintnews.org. I'm John Kelly. We'll see you next week.